one Danston in Ngonga. He has nothing to do with the investigations. The files will be investigated by the police and be sent to him. So dragging the DPP is far-fetched. Third, dragging our client, the CS for Interior, who is in charge of policy, is completely wrong. Well, first and foremost, it's on a light note that I was kicked out because I disrupted the proceedings. But again, thank you, my advocate, for fighting for me to come back. I was reinstated back to the proceedings. The judge is a classmate of mine, a deskmate actually, when we were doing master's class at the University of Nairobi 2009-2010. That aside, my instructions with the Nyaberi to represent the CS for Interior still stands, and we want to respond to what transpired in court today. One, we still have instructions to reiterate that it is not government policy. It is not the CS's policy. It is not the Ministry of Interior's policy. Neither is it the policy of one Kipchumba Murkomen to condone, to uphold, and to allow abductions of Kenyans or even any foreigner. That is the policy of the CS. Number two, we still reiterate what we said yesterday, that this is politics that is being played around. The petition was filed by the Law Society of Kenya. Surprisingly, the people pursuing the agenda are politicians. It is not clear how the likes of Babayao, how the likes of others come to be the forefront over issues of children who have gone missing. Third, I raised this issue that when you look at that petition, the people, the parties that have been put there, one, you are suing the director of NIS. NIS is an entity that cannot be sued, and it cannot sue anybody. The powers of NIS is purely to gather intelligence. Trying to bring in one Nuruddin Haji is purely out of place. NIS has no role in internal security. NIS has no role in terms of investigation. NIS has nothing into this matter. Number two, suing the director of public prosecution, one Danston in Ngonga. He has nothing to do with the investigations. The files will be investigated by the police and be sent to him. So dragging the DPP is far-fetched. Third, dragging our client, the CS for Interior, who is in charge of policy, is completely wrong. It is also our submission that the order for the production of the IG is completely out of order. The IG has delegated officers, starting from the inspector, from the director of criminal investigation, the regional commanders, the OSPDs, and the others. We shall be advising our client, one Kipchumba Murkomen, to advise the IG and the AG to move with speed to the Court of Appeal to stay the orders for the IG to be produced in court. The IG has officers just like the CJ. We have never seen where a matter involving a resident magistrate, the CJ is required to appear in person. There are people who are there who appear in person. The IG appears in Parliament. And if this matter goes to the Parliament, the IG will appear, he'll defend himself, he'll provide evidence of what he knows and what is not known. We raised also the issue that all those young people who have been found, it is not true that they have been released. The term release is synonymous with them being released from a police station. None of them has identified which police station, which cell, which OB occurrence number that was put. So it is not true that the Inspector General released any of those people. Investigations are going on, and the investigations will cover. If it is the police officers, they will be arrested and be charged. If it is a criminal gang, it will be arrested and be charged. Mark the CS's words. Kipchumba Murkomen is open to any information coming, and he will defend his position very clearly and ensure that the rule of law is maintained. Those are the remarks of the CS for internal security.